Hello, this is Matt on the Moon Lambo channel, and I definitely have a treat in store for you today. There's a new legal document that was filed today on Ripple's behalf, and it was filed by none other than Andrew Seresny, one of the attorneys representing Ripple. Now, Andrew Seresny, he's a former SEC director, and you know what I thought of as soon as I read this? Because, look, in going through this document, I learned a number of things that I was unaware of, so I think you guys are really going to enjoy this here. But you know what I thought of? I thought of a tweet from a Ripple employee, Stuart Alderodi. Here you can see his Twitter profile. General counsel at Ripple, over 30 years of legal experience with expertise in banking, regulatory affairs, and complex litigation. And I remembered a tweet of his, which I looked up. It's the one on your screen right now from December 22nd, 2020. And he wrote the following, and I thought of this tweet as soon as I finished reading this document for the first time that was filed by Andrew Seresny today. And Andrew, again, Stuart Alderodi, December 22nd, wrote the following. It's easy to play amateur Twitter lawyer. Wait till you see the real pros in action. Michael Kellogg has argued 14 cases in the Supreme Court and hundreds more in courts of appeals nationwide. Check out Andrew Seresny plus the rest of DNP's team as well. So that'd be Devawas and Plimpton. That's the law firm he's with. But I thought of that. I was like, yes, indeed, Andrew Seresny, definitely one of the real pros. And so while I haven't physically seen him in action in court, just seeing what was put together here, it's impressive, even for people that don't have a legal background like me. I don't have a legal background, and so just to be clear, I'm not offering legal advice of any kind. Even for somebody, just a lay person like myself, reading through this, the way this document flows and the degree to which it's logical and the way that they rip apart the SEC's arguments, it's incredibly impressive. It's just a delight to behold. I also do want to be clear, I don't have a financial background of any kind. I am not offering financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast that likes to talk about Ripple and XRP and crypto-related stories and topics and make YouTube videos about it as a very fun hobby. But that is all that it is. And so here you see, this is Andrew Seresny on his law firm's webpage here. And so it was just a few years ago that he was with the SEC. You can see this titled Enforcement Director Andrew J. Seresny to leave SEC. This is on December 8th, 2016. So just several years later, the SEC just... Man, what a train wreck. What a train wreck. And that's why it's so powerful to have... And he's not the only one from the SEC. Mary Jo White, also another attorney previously with the SEC. She was an SEC chair, in fact. And they're both like, mind you, long history with the SEC, and they're saying, no, the SEC has got this wrong. We know, we were there. Like, we know what would be right and just here. And so James Fallon, an attorney that's been keeping up to date on what's been happening with the Ripple and XRP case, the Ripple and SEC case, rather, shared this and wrote, Ripple Labs' response to the SEC's March 9th, 2021 letter stating that it intends to move to strike Ripple's lack of fair notice defense. And so just to briefly catch everybody up in case you've missed some of the details along the way, a primary argument of Ripple's is that, of course, as you well know at this point, I'm sure, Ripple, they've been in business a while, since late 2012. And along the way, sold a notable bit of XRP, engaging in all sorts of very transparent business actions. And given how long these activities persisted, it's pretty damn clear that if they were doing something wrong, the SEC should have provided fair notice. And they didn't, which, by the way, caused all sorts of harm as a result of their inaction. It resulted finally, it culminated in something that was just exponentially worse than it otherwise would have been if the SEC had just provided some damn clarity years sooner. But they didn't do that. And so this is a legitimate legal defense, as you'll see here. And so Ripple made that case. They filed the legal document indicating, hey, here we go. This is a defense that we are using. The SEC filed a document trying to strike it so that they can't use it. And the truth is, it's because the SEC is afraid of it. Attorney Jeremy Hogan even brought that point up. Why else would they go after it in this defense? Because clearly it deserves to be addressed here. And so this document that came out today is the response to that. And it begins as follows. And again, this is written by Andrew Serezny to the Honorable Annalisa Torres. That's the judge that is presiding over the SEC versus Ripple case. Dear Judge Torres, we respectfully write on behalf of Ripple Labs in response to the SEC's March 9th, 2021 letter stating the SEC intends to move to strike Ripple's lack of fair notice defense. The SEC's anticipated motion to strike is meritless. The striking of affirmative defenses is disfavored in this circuit, and the SEC cannot remotely meet the high burden of showing that there is no question of fact or law that might allow the defense to succeed. First, Ripple's lack of fair notice defense more than satisfies the liberal pleading standard and thus cannot be struck. Second, Ripple's fair notice defense requires factual inquiry and context, which is why courts address this defense on the merits with the benefit of a developed factual record. Significantly, the SEC's pre-motion letter cites not a single case, zero, in which a court struck a fair notice defense at the outset of litigation, and Ripple is unaware of any such authority. So pause and just think about that. The SEC is seeking to have this fair notice defense completely struck so that they can't use it, which has tremendous implications I've talked about in previous videos. It would be bad. It really would be bad. And there's no precedent for this. They're just saying, we don't like it. So they try to make it sound all professional and legal. I covered it. And I like when I covered that document, which again, it's outside the scope of this letter. This video would go on for hours if I cover every single aspect of this in depth. I've already talked about all these things thoroughly on the channel, but in covering that letter, even not having a legal background, just as a layperson myself going through it, I was like, your logic does not follow. Holy hell, who do you think you're tricking? It's like, it's just a bunch of, it just struck me as completely disingenuous, but they're going to do whatever they can. It's like a Hail Mary attempt, but we'll see here. Then they write, Andrew writes, third, even if the fair notice defense involved a purely legal question, which it does not, the Second Circuit has cautioned that disputed and substantial legal issues should not be decided on a motion to strike without the benefit of a developed record. Fourth, the SEC cannot show prejudice of awaiting adjudication on the merits. And then they have this, point one, the burden for striking an affirmative defense is incredibly high, and the SEC cannot meet it. To succeed on a motion to strike an affirmative defense, plaintiff must show that, 1, there is no question of fact which might allow the defense to succeed. 2, there is no question of law which might allow the defense to succeed. And 3, the plaintiff would be prejudiced by the inclusion of the defense, and will not be granted unless it appears to a certainty that the defense cannot succeed, notwithstanding any facts that could be proved. And by the way, somebody caught this here. You know what? I was going to share this at the end of the video. I'll just tell you right now because we came across it right here. So they're citing case law along the way, and I'm doing my best to just skip over it instead of accidentally reading it. So if I accidentally start to read it, I'm going to catch myself hopefully and stop. But it flows along with the rest of the paragraph, so I'll just have to be careful. But check this out. Somebody caught this. Attorney Jesse Hines responded to this piece from Andrew Serezny and wrote, this attorney Jesse Hines wrote, solid response from Ripple, the fight continues. And somebody named Matt said in response to that on Twitter, I like how they referenced Judge Torres' case in the response. And Jesse said, where was that? I missed it. And Matt responded right there by highlighting it. And Jesse wrote, that is her case. Good catch. And so indeed, in Andrew Serezny making his case here, there's legal precedent from a case that involved Judge Annalisa Torres, who is presiding over this case. I just thought that was freaking cool. So I was like, here, your law says. You know, I think he's doing it all tactfully, obviously, but it was just kind of neat to see that here. And so anyway, it continues. And where's that start? Okay, and will not be granted unless it appears to a certainty that the defense cannot succeed, notwithstanding any facts that could be proved. The SEC's own letter acknowledges that such motions should be denied unless the challenged allegations have no possible relation or logical connection to the subject matter of the controversy and may cause some form of significant prejudice. Yeah, and right there. And so logically, what Ripple put down, you know, in just the initial document citing, hey, this is our case having to do with, you know, on the topic of fair notice. it does logically follow. It certainly clearly seems very relevant. And so if it's, you know, if it ends up being the case that it's not sufficient for them in court, well, so be it. But this idea that it doesn't, you know, doesn't rise to a level of some sort of relevance in this case, that's the part to me that was just incredibly disingenuous, right? And then Andrew continues, nor should disputed or substantial issues of law be determined on a motion to strike. The Second Circuit has endorsed the view that even when the defense presents a purely legal question, the courts are very reluctant to determine disputed or substantial issues of law on a motion to strike. These questions quite properly are viewed as determinable only after discovery and a hearing on the merits. Exactly. So it's like, think about it, just imagine this. Ripple's like, here's a bunch of evidence that's completely relevant, and then the SEC's like, no, we don't want your relevant, we don't want any of your relevant defense or any of your relevant evidence in this case whatsoever. That's basically what the SEC is doing, and that's why I'm just like, you guys, you little bunch of, you like little army of asshats, you know what you're doing, and it's not ethical. It is definitely not ethical. Number 2 here, lack of fair notice is a well-recognized affirmative defense to a government enforcement action, and Ripple has adequately pled it. Lack of fair notice is a valid constitutional defense to a government enforcement action. It is rooted in the Due Process Clause's requirement that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited. This defense prevents a government agency from penalizing someone for violating the agency's interpretation of the law when, in fact, there was no fair notice to the public of what the interpretation was. Exactly. And there's literally video of David Schwartz, who's Ripple's CTO and co-creator of the XRP Ledger, years ago, saying, can you just imagine, because we're not getting sufficient regulatory clarity from the SEC, I'm paraphrasing, but this is the message he was conveying, can you imagine we're not getting sufficient regulatory clarity, and then at some point somebody comes after you and sues you and told you, yeah, what you've been doing all these years all along, it was illegal and you should have known better, which has pushed people when starting companies in the blockchain industry outside of the United States because they don't know for sure if at some point some sort of branch of the federal government would come after them. And here you go. Happened to Ripple. Anyway, his letter continues. Upton is the leading fair notice case in this circuit. It vacated an SEC enforcement action in which the SEC sought to penalize Upton for violating a rule in the face of substantial uncertainty in the SEC's interpretation of that rule. In concluding that the SEC's enforcement action amounted to a substantial change in enforcement policy that was not reasonably communicated to the public, the court made factual findings that the SEC had been aware for years that market participants were engaging in the practice at issue, that the SEC knew from its third-party communications that market participants lacked clarity as to the SEC's position, and that the SEC nevertheless took no steps to advise the public besides issuing one prior consent order that carried little precedential weight. So think about that. There's already precedent here for this. The degree to which the SEC took no action, it's just the level of inaction here makes it completely unreasonable for them to then years later come back and say, well, you should have known better. They didn't know better. Like, they didn't know. Or else they would have brought action sooner after almost an entire decade. Come on. Anyway, the Second Circuit later described the due process problem in Upton this way. And here's a quote. The SEC's interpretation, which was never officially published, converted commonplace acts in the industry into violations. Ding, ding, ding. And so there you go. And here's what's at the heart of the matter. Because again, commonplace acts, the SEC action converted commonplace acts into just completely common in the industry into violations. And so if Ripple really gets taken to the cleaners here, and if they're not allowed to sell XRP, and XRP is deemed to be a security, which I don't think is going to happen, but if it were to happen, then what is not a security? Because all of these actions, what company in blockchain that launched a cryptocurrency didn't in some way take some sort of monetary benefit from it? It's just. You're churning what has been commonplace into violations, which is not to say that there couldn't be clear violations of the Howey test, or that there could have been investment contracts sold in an illegal way. I'm not even saying that. I'm just saying in terms of what has been done in commonplace, which you approved of, SEC, by verbally giving the thumbs up to Ether and the Ethereum Foundation. Like, what in the ever-loving hell are you talking about? What a disconnected form of logic, or, well, lack thereof, I suppose. Anyway, it continues, though. Similarly, United States v. Anzalone dismissed charges of violating a financial reporting statute where the government's own conduct created the ambiguity and confusion in the minds of market participants as to the law's reach. It was anathema to the First Circuit Court of Appeals that the government nevertheless decided to test the limits of statutory interpretation by charging the defendant. Does that sound familiar? Does that sound familiar? Yes, absolutely it does. Let me go down here. The courts in Upton, Anzalone, General Electric, and Exxon, and those were cited in cases which I'm glossing over here, of course, all decided the fair notice issue on the merits based on a fully developed factual record. In its fourth affirmative defense, Ripple alleges it did not have fair notice that its conduct in selling the virtual currency XRP violated the law, or that the SEC interpreted the term investment contract to encompass Ripple's sales of XRP. Specifically, Ripple's answer to the first amended complaint alleges that prior to the SEC's filing of the complaint, countless market participants had for years transacted in XRP and did so with full knowledge by the SEC. Well, how about, see, that gets to the heart of this for me. Like, that's why it's so freaking disingenuous to go after Ripple in this case. They know what they were doing, and if what Ripple was doing is wrong, then shame on the SEC for not protecting innocent investors sooner. Now, of course, I don't believe for a moment that what they did was right, but if it was right on the merits and legally, shame on them for not acting sooner. Either way, they're still a bunch of asshats. Anyway, XRP was publicly listed on over 200 virtual currency exchanges. Selling XRP was commonplace in the industry, with billions of dollars in XRP bought and sold each month. XRP was used as a bridge currency and in third-party products. Market participants reasonably understood, based on the statutory language, case law, prior actions by other regulators, and enforcement actions and public statements by the SEC and SEC officials, that XRP was not a security, and for years, the SEC provided no contrary indication as the XRP market flourished. Meanwhile, regulators in Singapore, Japan, and the UK made clear their views that XRP was not subject to securities regulation. Now, so I don't blame them for bringing that up. I've talked about this on the channel before, but, you know, and I'm not saying this from a legal perspective, from a logical perspective, you know, I know this sounds good for the SEC, but I like to just be an honest analytical thinker here. In terms of what's a security, the United States government considers what is security, like a quote-unquote security, to be something completely different than what would be a security within the legal framework of other countries. And so, to me, it doesn't completely line up. I'm just saying, like, for me, from a logical perspective, I don't find that to be the strongest argument. I think it's perfectly fine that Andrew Szczesny brought it up, not even from a legal perspective, because I can't tell you what's a good legal defense or not. But just from a logical perspective, I still don't blame him for bringing that up one bit. I get it, because it brings home the idea that nobody thinks that this is something that represents ownership in a company. That's just one of many points you could bring up on it. But I get it. I'm just saying, like, for my humble opinion, just from a logical perspective, not a legal perspective, I just don't think that's the most powerful position. But you know, there's all sorts of other really powerful statements in here, obviously. So we'll move on now. But market participants also explicitly communicated to the SEC their views and analysis that XRP was not a security, and after those communications proceeded with XRP transactions. The SEC's own actions, including its communications with third parties, the declarations by senior SEC officials in 2018 that Bitcoin or Ether, and he writes in parentheses, the digital assets XRP most resembles, are not securities. So there you go. They're saying SEC said Bitcoin and Ether are, on a scale of 1 to 10, 2 thumbs up, not securities, and XRP is... it resembles those, you know? And so if those aren't securities, how the hell is XRP? Then he continues. And its enforcement actions against other entities like Kik and Telegram, which used initial coin offerings, or ICOs for short, or simple agreements for future tokens, and engaged in conduct that did not resemble Ripple's, impacted market perceptions, exacerbating the lack of fair notice that transactions in XRP violated the law, or that the SEC would later claim Ripple's sales of XRP to be investment contracts. See, that's powerful to me. Now, this lack of fair notice was compounded by the 2015 settlement between Ripple and FinCEN and the U.S. Department of Justice. And check this out. Declaring XRP to be a convertible virtual currency. And so we were aware of that, but check out this sentence. That's a classification fundamentally incompatible with XRP being a security. So right here, Andrew Szczesny is arguing that it cannot be both. And the SEC is trying to argue that it can be both at the same time. Did you know that a giraffe is also a banana? I'm telling you, it's true. A giraffe, indeed, is a banana. It is one and the same. Andrew Szczesny doesn't think so, right? And so it's a classification, again, fundamentally incompatible with XRP being a security. And moreover, Ripple's subsidiary, XRP2, by the way, it's actually XRP2 LLC, which sold XRP to institutional counterparties in over-the-counter sales, was subsequently regulated as a money services business, a business over which the SEC has no regulatory authority, and that is regulated in a manner inconsistent with XRP being a security. And that's something that I didn't know. I had not seen that argued before, but I did know XRP2 LLC was a registered money services business that Ripple used to sell XRP as a result of what happened in 2015 with FinCEN. But I didn't know that as a result, this is what Andrew Szczesny is saying, that as a result of the way in which the business is structured, it's a registered money services business. The SEC has no regulatory authority over it. And so that's kind of fascinating. I just hadn't seen that articulated. Number 3, Ripple's lack of fair notice defense cannot be adjudicated on a motion to strike. The SEC's anticipated motion to strike is fatally flawed at the outset because Ripple's lack of fair notice defense is well pled. It states a valid defense and sufficiently alleges facts. Nothing more is required. And then, let me jump down a little bit further. Yeah, here we go. The SEC's burden is further insurmountable because a lack of fair notice defense involves factual inquiry that makes it particularly unsuitable to resolution at the pleading stage. No wonder the SEC has cited no case in which a federal court has struck a fair notice defense. Instead, the SEC tries to sidestep this issue by relabeling Ripple's defense as an equitable defense of laches or estoppel, or as a void for vagueness defense, failing to even cite the seminal second court case on a fair notice defense. But Ripple has not asserted those defenses, and the SEC's attempt to change the subject and create a straw person should be rejected out of hand. And so there you go. They're literally arguing against Ripple for a statement that they didn't make. That's what the SEC is doing. Now that is incompetency, or they're just disingenuous. And I'm going to assume that if they made it to the SEC and their lawyers, they're probably not stupid. They're probably asshats. I'm just going to guess. Nor can Ripple's fair notice defense be adjudicated on the pleadings as a matter of law. The SEC will argue that this case involves the straightforward application of the decades-old Howey test. We strongly disagree. This enforcement action represents a significant expansion of the SEC's interpretation of the law. The SEC is attempting to argue that Ripple's sales of XRP were investment contracts under Howey, when this case presents novel and unprecedented questions about the application of that 75-year-old case to innovative assets like XRP. Just by way of example, XRP is a digital asset with inherent uses and utility. Ripple did not have anything resembling a contract or agreement with XRP holders, most of whom purchased XRP in the secondary market, not from Ripple directly, and even where Ripple sold its XRP on the secondary market, such sales were conducted through cryptocurrency exchanges where the counterparties to the transaction were unknown to each other. There was no common pool into which all proceeds of XRP sales were deposited to support the XRP ecosystem, and XRP's price was not correlated to Ripple's efforts, belying any claim that holders were relying on their efforts. There is no precedent holding that an asset sold under these circumstances could be an investment contract, and actions by the SEC and other regulators suggested otherwise. Whichever way this novel issue is ultimately adjudicated, it cannot be adjudicated on a motion to strike. because it raises a substantial issue of mixed fact and law that must await development of the factual record. Furthermore, the SEC's citation of 2 Second Circuit cases from the 1970s involving facial vagueness challenges to the term investment contract are inappropriate. Neither involved a lack of fair notice defense or even an as-applied vagueness defense, and neither provides legal grounds to foreclose Ripple's lack of a fair notice defense at this early juncture. And so he's just ripping this to shreds. The degree to which the SEC had just put this letter out there, which, you know, for a layperson like us reading it, it just sounds very professional, this and that. And it's a bunch of gobbledygook. Gobbledygook, say it with me, it's a fun word. The SEC put out a page full of gobbledygook. Bunch of asshats. And then, to wrap up, he wrote the following. To the extent the SEC will argue that Ripple had fair notice because it knew the SEC could interpret the law to prohibit Ripple's conduct, that too is a substantial issue that cannot be determined on a motion to strike. The mere theoretical risk that a government agency could or might interpret the law to bar conduct that went unchallenged for years is not the same as providing fair notice. And then he cites a case right there. Yeah, I'm going to skip that part. The bottom line is that courts must wrestle with factual context in deciding what constitutes fair notice in a particular case. Such questions of mixed fact and law are to be decided based on a developed evidentiary record, not on a motion to strike. And finally, the SEC cannot show any prejudice of waiting for adjudication on the merits. The factual issues relevant to Ripple's fair notice defense overlap with the same issues core to the SEC's case and Ripple's other defenses, as Ripple addresses at length in its motion to compel, now pending before Magistrate Judge Netberg. So there you go. And we'll wrap that. We'll let it wrap up there. But I'll tell you what, Andrew Seresny, he is a legal ninja. You know, he's lawyer ninja, absolutely killing it. So this is what Stuart Alderoni, what he wrote here. Again, wait till you see the real pros in action. Well, we're seeing him in action here, and I understand it's just a document, but holy hell, you can see what Ripple's working with here. And the SEC, it seems to me that their team, they're out of their league. Like, putting this nonsense together like it wasn't going to get called out by a former SEC director who's a lawyer for Ripple. Did you think that it was going to get past him, and that the case law that you cited there as a precedent, you'd think he wouldn't know what that was? Or if not, if he didn't know off the top of his head, do you think he wouldn't research it to find out that it doesn't even have anything to do, like it doesn't even defend your point because it's irrelevant? It's a bunch of gobbledygook. Now that I got a kick out of it, so I learned a bunch out of this, and it was really cool just to see how he put this whole thing together. So, wow. This is powerful stuff. I tell you what, I do not envy the SEC lawyers that are having to go up against Ripple's team. I would not want to, because it's logically nonsensical, and I just don't think that the law's on their side. Even if they technically end up winning the case, and you know, even if it's proven in the court of law that the way in which XRP was sold as an investment contract, that doesn't mean today that XRP is a security, and it doesn't mean that Ripple shouldn't be able to continue on with their business model. So as long as that doesn't get gummed up, then I'm cool. But I will go ahead and wrap up there. Thank you for hanging with me to the end. I hope that you found that as interesting as me. This is, I don't know about you guys, but it's so logical and rational that I just sit here thinking, like, the more I learn about this, the more legal documents I'm reading, I'm just like, how could Ripple not ultimately be okay when this is all said and done? But I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.